to the Quinoa podcast today, everybody. We've got Suraj with us. How are you doing, Suraj?
I'm good, thank you. I'm very well.
Would you like to tell us a bit about who you are and what you do?
Yeah, of course. So I'm the founder of Soul Legal Services, and we are a business-to-business type business, and we help any businesses really. A lot of the time, it's the small startup businesses, and we sort of help them through their journey, the contracts journey, just with what to do and where to go and what's right for their business at this point in time. And sometimes we get a sort of a destination where they want to be at, and we help them just along that road and fill in some of the gaps that they might have along the way.
So this is a really interesting topic for me, I think, because when we start as a business and we start as an entrepreneur, we come up with an idea and we think, okay, I want to get a company. What do I do? Do I become a sole trader? Do I become a limited? Do I need a contract?
Yeah.
How on earth do I do it? And this is really, it can be really, really confusing. What kind of things do people need to be thinking about at this stage?
Well, let's start from right at the beginning with that then, with the sole trader stuff. There tends to be a lot less paperwork involved as a whole when you're a sole trader, even with regards to the tax and the accountant stuff, and especially on the legal side of things as well. So the one that's sort of a blanket one for whether you're limited or you're a sole trader is depending on what you're doing, but terms and conditions or terms of engagement, whatever you might want to call them, are always really important things. And it's not really something that, although it is a type of agreement contract, it doesn't need to be something that's really bogged down legally. It's more of just an explanation of what's going to go on. So I'll give you an example. I'm working with someone at the moment who is doing them for, he offers training for drivers. And there's various different packages. He has about 4 or 5 different packages, and now he's got another 2 because of them all being online. And he's found it really helpful that we're stepping through and describing exactly what happens in each scenario. So in each package that he delivers, in his terms and conditions, he's been able to explain, this is what I do. And really importantly, he's been able to explain what he doesn't do, what the scope of the work that is, and the time limits that are involved. So for example, with him, a lot of the stuff he needs to be able to, in current circumstances, needs to make sure that it's COVID safe wherever he's going. And they need to make sure about that. And they need to just make sure that the drivers are there, make sure all the licenses and any agreements and their driver's licenses and all the vans and the trucks and everything's just been MOT'd and serviced and all the rest of that sort of stuff. That's not his problem. So he's got to explain that I can teach you how to drive safe, for example, but if you've not serviced your vehicle or your drivers are tired and they haven't had enough sleep, etc., that's not covered under this. This is just what this is. And it's really good for the business owner as well, because especially early on, because you're a little bit confused as to where your business is actually going. And for me, everyone was telling me to niche, and I wasn't really quite sure how to niche or where to niche because it was very broad. And then a lot of people were saying, well, you've got to cast your net wide. Well, there's contrast there then. So it's good as a business owner because you also get it down on paper where it is, what you're doing, and just explaining your services. And that can work for a limited and a sole trader. It's always just good to have those. And because it's not a document that is really, really extensive, it's not something that's going to cost thousands and thousands of pounds. And you can tweak it as time goes on, tweak it in 5 years' time and 3 years' time when a bit of the business changes. And also, something I always say to a lot of my clients is keep a Word document open on your laptop or a piece of paper on your desk. And when something goes on and you think, well, do you know what, I wouldn't mind having something like that to make sure this doesn't happen in my terms and conditions, or to make sure that if this does happen, there's a protocol that I've got to follow. Time limit for me is a big thing because I've got to some things can take 3 weeks. So I need to have a stipulation in there that says, well, it might take 3 weeks. And even if it takes a little bit longer, I will make sure I contact you at the earliest possible stage. I'll give you a few days to sort of come back and just review it if you've got any questions, etc., etc. So that's a really good one for me. It's just a safety net, and you don't need to be like too strict in your terms and conditions because you need to be able to have a bit of flow as well. And then for the limited companies, I'd say the same. They need their basic stuff, so they need the articles of association, etc., which will be given to them if they want them by HMRC. So they don't need to really worry too much about that. An accountant can sort that out for you as well. But one of the first things that they will need is the terms and conditions. And I'd probably discuss with them a little bit about contracts, depending on what it is that they're doing, especially if it's a product-based business, or there's someone's got to give them something before they can sell their product, and there's transport involved, etc. I'll probably just have a word with them about contracts.
I think this is really interesting as well, because as a business, you can have some terms and conditions, and another business can have some terms and conditions. So if your terms and conditions aren't meeting in the middle, or you've maybe got an NDA that's not meeting in the middle, and you've both got different things that you need to put in there, how can you get around that if, I don't know, neither parties may be willing to budge on their terms and conditions?
Yeah, that's an interesting one. So really, you need to agree to both. So there can be a meeting in the middle if you wanted it to be, and that would just be a negotiation thing. So it would just be the two sitting down, and what you'd have to do really is you'd have to do away with the ones that you've got. They'd have to do away with the ones they've got for this current scenario, and then you'd sort of just draft maybe a terms of engagement type thing, or even what it's like a board minutes, but it's not a board meeting. So you just sort of write down, this is, okay, I agree to this and I agree to that. But really, in that scenario, if you're happy with what their terms and conditions are, and you think, yeah, I can work with that, and they can work with yours, there really doesn't need to be anything in between. Sometimes that's just going to make life a little harder, and it'll take a little bit longer. But it also depends on how much that project or that contract is worth. And if it's very, very lucrative and niche, then it's quite important to get that down. So another example here is I'm working with a business based locally that does basically 3D printing machines. And there's quite a niche area of what they print and the special powders that they use, and they've got a deal with a business in America that they're working with at the moment, and they sort of want to they've got their own terms that they normally use if they're leasing machines out in England, but this is a bit different. It's on a bigger scale. So we're sitting down and we're sort of saying, well, let's have a look at the email trail that you guys have done. Let's have a look at anything that they might have sent over and pick out the bits that are more terms and conditions rather than a general conversation. And then maybe we can get that on a piece of paper and the two parties can agree that. So in that scenario, you would need another one. Otherwise, I think it would just be a bit of a waste of time and money to get brand new ones drafted every time someone brings their terms and conditions to you.
I wanted to ask about NDAs as well, because I just mentioned those. So a non-disclosure agreement, how important are these, and when should you use them?
They are very important, and they need to really be thought about, again, depending on what it is that you've got. If it's something that's, and a lot of the time it is as business owners, it's all innovative, it's fresh, it's new, it's something that's totally different, and it's not out there, or at least it's not out there in that particular capacity, even if there's something small that's different. And the non-disclosure agreements there are important. And the most important time is early on, when you might just have a bit of an idea, and we all need it, and you've got to go and ask people questions. How would I do this? How would I do that? Even if it's your local university or it's your local chamber of commerce, you're having these really important conversations it's important to your business, but the stuff that you're talking about is very important to the asset that's going to be your business, the goodwill that's going to be your business. And without that, you're not going to be able to really build and make money on it. So that's when non-disclosure agreements do need to be signed. And all it's doing, again, this isn't something that's massively complicated. It's not a really, really long document, but safety-wise, it's really important. So what it will give you is the ability to talk to someone and be comfortable that they can't then take your idea or even little bits of your idea and give it to someone else or talk to someone else about it, because it could be just that little bit that's different. And especially with someone like a university or a chamber of commerce or something like that, they're going to be speaking to a lot of business owners, and little things like that might come out can just dramatically change someone else's business and ruin yours. So that's the most common scenario that they can be used. And for me, I use them because I might be sending out a document like a generic terms and conditions or a generic set of shareholders agreements. I own that, and I've written those. So if I'm just saying, are you sort of okay with this? Does this sound all right? We can move this around, we can move that around. And another example for me is I will have special confidentiality clauses or data protection clauses. Those are the clauses that I own because I've written them. So there could be a non-disclosure agreement there as well. So it is really, really important to have it very early on, and it gives you a lot of safety.
You mentioned shareholder agreements there. What are those and where do they apply?
So they apply. And it depends who you speak to, I suppose, in some scenarios. A lot of the larger businesses, because I work with some businesses that might be raising funding through venture capital, so they would be registered as with HMRC as SEIS or EIS, which gives their investors a lot of advantage. Some businesses will say, I only need it when I'm raising money because I'm issuing more shares in my business, apart from the 100 that might have been given when I set this up. I'm issuing more shares and now they're going to be worth a little bit more. I've got a lot more people involved into the business. So I need to get some stuff on paper and I need to get some certificates sorted. I advise that we have them early on, because those businesses that say I need a shareholders agreement later on will then say, oh, well, early on you have a co-founders agreement. I just think, why don't you have a shareholders agreement from the start? Because it doesn't make sense to then have two. So the shareholders agreement, it has to be a limited company for it to be a shareholders agreement. So if you're a sole trader and you've got someone that works with you and you set up this business yourselves, then a partnership agreement would work for you, or even a co-founders agreement, because you're not shareholders because it's not a limited company. So a couple of very important things about the shareholders agreement. They're quite similar to articles of association, but they've got a lot more detail in them. And one of the best parts about a shareholders agreement is that it's not a public document. So I can't just go online onto Companies House and see your shareholders agreement, but I can see your articles of association. So I can read through those and see how it works in your business, and what the articles might just say, but this is what happens when there's an argument between directors or something like that. Real simple stuff sometimes. But the shareholders agreement, the only person that can see it is me and you guys, whoever your shareholders are. We're the only ones that can see it. You guys are the only ones that sign it. So it allows for you to add in some really personal stuff, but that's very important to the business. So one of the most common things I have to write in is that someone's bringing £100,000 into this business, or someone's bringing some sort of an asset into the business, and the business then owes that money over a certain period of time, and they might be paying in shares. So it might even say you've got 45 shares and you've paid £100 for these shares. So there's a lot of talk about money, the debts, the creditors, when it's being paid back, when it's being paid in, what it's being paid for. All of this stuff you really don't want to be public knowledge. That's no one else's problem but the business's problem. So that's what's really good about the shareholders agreement. And what a shareholders agreement also does is it overrides the articles of association. So once you've got your shareholders agreement, although the articles of association are still there, your shareholders agreement is what's most important. So sometimes boringly, I have to add in some of the normal stuff of, this is what a director means, and this is what happens in board meetings. This is how resolutions are resolved, and some things like that. Some of the really important stuff that I always have to advise in shareholders agreement. One thing is called preemption rights. So these are rights for the shareholders to be able to have first refusal of new shares. So if anyone wants to come into the business and is putting in money, and they'll say, well, I want 100 shares for £100,000. The new shares that are then put out to the business for sale, the current shareholders will be able to say, actually, can I have 2 of them or 3 of them or 4 of them? Because I will reduce my shareholding. If you go and give 100 shares to this guy, so I've only got 3, I'm not going to have any room to maneuver here. So you've got that option to purchase if you wanted to, but also you've also then got the option of saying, well, no, it's okay that you're having these shares, but who's buying them? I want to know where they're going, and I'm not going to give you my signature or my yes, my hand up, until I know where they're going, because I want to know who's coming into this business, who's going to be having a seat on this boardroom table, and who's going to be able to have a say. So that's really important as well. And another big issue that is quite rare, but is really a big pain point when it does happen. There's a way that you can sort of force someone to sell their shares. And it happens in a number of scenarios, but the really important scenario is death. So if a shareholder, there might be 5 or 6 shareholders here, And if the shareholder dies and that shareholder says, I'm going to leave all of my worldly assets to my wife or to my son, that person that has died might have a 20 or 30% shareholding in your business, which is quite considerable shareholding. Now, all of a sudden, that person's wife or that person's son now has 30% shareholding in your business. They might not even care about your business. They don't understand how it works. They don't understand how business works, maybe. And then more certainly might not have the brand. They might not just feel the same about it. The decisions might not be the same. And this is where things can get really awkward. And I've seen businesses, unfortunately, go down because of this. And a lot of the times, really simple things like laptops and phones that are owned by the business. And it's written in the shareholders agreement that we own the laptops and the phones. You need to give them back to us as soon as we ask for it, because that's important. You've got all the email addresses and whatever else that might be on there. And sons, wives, daughters, sisters, whatever, have refused to give back laptops and mobile phones because they've said, well, no, that's my dad's or that's my brother's. And there's no shareholders agreement in place. So there's nothing to say that you've got to give it back. And then not only that, they're causing real issues because they're considerable shareholders within the business. They're not bringing anything to the business, and they're hindering it. It can be it's a rarity, but it can be a real problem. So that's a couple of the really important things that are in a shareholders agreement. They tend to be they're longer documents. They're very intricate documents. They take me a while to write, if I'm honest, because the complexities that are involved, you're talking like a few weeks for something like that. And it takes time. And there's a lot of meetings of minds as well, because I've got to go back and forth with the people to make sure they're comfortable with it and make sure what they want in is in there as well, especially when it comes to who's bringing in the money, when is that money going out. I can't have someone bringing money into the business and then there not being a set date as to when the money's going, because then the business that I'm writing a shareholders agreement for has got this infinite credit that it's got to pay off for the next 100 years. So I'll try and get something down. And the other thing is, I don't like to have, because I like to work with both sides here, I don't like to have the other party having spent £100,000 into this business and they don't actually know when they're getting the money back. So I try and get some stuff down on paper, but those are the few important things about shareholders agreements.
This sounds really complex. So I've got kind of two questions. Is this from when you take your first shareholder and then do you have to kind of start rewriting every time you get new shareholders? And is it good to kind of have maybe somebody like yourself on retainer all the way through this to keep it, in the form that it needs to be in, so that you're not getting behind in your legal agreements? How does all that work?
Yeah, so it does sound a bit complex and complicated, but it really isn't. And it's just I take it one clause at a time, and we take it step by step. When I'm talking about it, and you kind of can't see what I'm talking about, it is much harder, and sometimes there's a lot of words, and you think that's what the document's going to look like, but it's not. It is really, really simple stuff, and it makes sense once it's put together in one document. And with regards to when, if there's two people, that's probably from the point where you start with that agreement. So you might take somebody on, or it might just be you started this with someone else. So that's always a good time to start this. And when you take new ones on, if it's done properly and you're still happy with the way that things are going, there is no reason why you would need a whole new one. The only thing you would want to do is you would add their name onto it, so they sign it, and you've basically got a brand new shareholders agreement there with all three of you signing it, or all four of you signing it. There's no point in just rewriting them all the time, because they are complex documents, and they're not documents that are a few £100s either. So you don't want to be shelling out every other year for a new one. And then with regards to the retainer type things, it's something I offer in my business, but I don't always offer it, because some people and some businesses don't need it. And there's no point in you shelling out a few £100, and it might even be more than that, per month, just for a retainer of someone that you might just phone once a month or something like that. That's quite simple stuff, because you can do it under an hourly rate. But there are some businesses out there that just might do it for 6 months because they've never really had anybody have a look at any of their documents. They're not really quite sure what they're missing. They don't know what they might have something that's similar to a document, but what's in there, what isn't in there, are we aware of what goes on, and things like that. There's a lot of the times I review documents and advise people, and sometimes, and I did it again twice this week, and I said, to be honest, I'm not quite sure the other side are even aware that this clause exists in their document. So that can happen quite often as well. So there is the retainer element, but I always say be a bit careful before you do that, because it might be something that you need every now and again. So you wouldn't want it being a waste of money. And in my situation, I'm always going to be here. So you can always phone me or email me, whatever, we can sort something out. So I'm not disappearing. So be careful with the retainers. They're not always necessary.
Are there any other major considerations that people should be thinking about when they start to kind of own their own company? Are there any other main legal concerns that you want to bring up?
Yeah, so if we go with the shareholders agreement, obviously is one. The terms and conditions, the non-disclosure agreements, and then contracts is the fourth one. And that could be, it's very wide when I say contracts, because it could be pipeline contracts, it could be contracts between you and a service provider, or you and a provider of a certain bit of stock, or a certain element of what you sell. It could be something, even the lease of a property, anything like that. All of those things need to be considered, and I think sometimes people won't do that, or they'll just go, it's fine, whatever it is. And then when I'm doing things like that, I will always offer additional advice, and I will say, well, have we got a backup here in case something goes on? And I used to do it for years and nothing ever happened, and then Brexit happens, or a pandemic happens, and all of a sudden we haven't got a backup. We haven't got someone a bit closer to home that can kind of provide the same thing that we need, maybe at a higher rate, but if we really needed it, it's there. And often business owners don't think of that. So we'll got that one, that'll do, and we'll go with that. And then we then have to think about, depending on where they're coming from, are they coming on a ship, for example, have we thought about the insurance and things like that? So a lot of the other stuff I can sort of dig around. Although I'm not an expert in it, at least I can say I suggest that. And then the only other thing I always say is, think about where we want to go with this business. Think about where you want to be in about 5 or 10 years time, or something like that. And I'm not saying, well, if that's where you want to be, start getting all these documents in order, because things can change all the time. But at least think about that, because what I can do now, I can maybe change one or two really minor things in your shareholders agreement that will make it a lot easier. For example, with the preemption rights, if you're bringing on a shareholder that's a venture capitalist, they might want, I know that they prefer to have those rights in there, because it's a safety element for them once they're in, that when there is another one, they have the option to go, actually, this business is going quite well. I can see this really going forward. There's 100 shares here. I want 50 of them, because you're bringing on another investor who although I get on with, and we've got this thing going on, but I still want to have a majority share, or I still want to have a considerable shareholding. And then what it will save you doing is writing a whole new shareholders agreement in a few years' time, just at the point where they're ready to give you £100,000, and you're saying, oh, wait, hang on, I just need to rewrite the shareholders agreement, so hold off on the £100,000 into my account. We don't really want to be doing that. We want to make it as smooth as possible. So always just think about, we don't have to put anything in place at the moment, but at least if I know, I can make provisions really early on, and I can say, well, let's have a real good foundation here of X. We can then build upon this next year and the year after and the year after that. Just makes life easier for everyone.
So an interesting question that sometimes comes up is, if I can get these legal agreements on a template online, should I do that because it's for free? And I've kind of been through that thinking process, but when I went to a lawyer to get an agreement drawn up, it was 28 pages and not the 3 that was online. So what would you say to people that are looking at that option instead?
Look at the option. I mean, the option's there. I have no problem. I know people are going to do it, and I know people do it. It's fine. And what this is an example I often use, because I had a client that came to me that had just started her business in the pandemic, and she was selling holidays in campervans in England, and she went from just starting to just absolutely nothing, and she had a co-founder, and she said, I've got nothing. I've got some terms on the internet on my website, and that's about it. We don't have a shareholders agreement. And it was really important, because of her particular scenario, that she had a shareholders agreement with her co-founder, and she didn't have the money. She did not have the money for it. She had a few £100 and she was going to put a few hundred in herself. And the co-founder was, and they said, we just need to get something, but we really haven't got that sort of money. And we're doing other things and the vans need servicing and whatnot. So we found a way where she could actually sign up to a local chamber of commerce, I believe it was, where she'd be able to get a free template. So I told her to do that and take the full advantage of being with the Chamber of Commerce. Download this template, and I said, work on that. Just there's steps on it. Take those steps. When you've done that, send it to me for a review. It'll cost you a third of the price. So it's really not a problem. As long as you know that the ones that you've got, you can't just print them off and use them. They're not written for you specifically. They never are. They're written from anyone that might be a VA to someone who is transporting cars worth hundreds of thousands of pounds each, and everything in between. So it's okay to get them. They're definitely there, but make sure you read through them. Make sure you've deleted some of the stuff. They always have optional clauses in. So they'll say something and then they'll say or something that's the direct opposite of what they've just said. And then there'll be another or with a third option. And people leave them in. Well, you might as well not have a contract because you've got 3 contradictions within a contract that you've just signed. So delete the one that you think is irrelevant. And if you've got someone like me that's reviewing it afterwards, highlight it and you say, I don't think this is relevant because of this. Should I delete it? Leave that to then your reviewer to sort out. So you've done a bit of the legwork, and it works out very well for some clients. It's really cost effective for them. It's quicker, and they just understand it. I like my clients understanding the contract and knowing what's there. And with regards to the 28 pages or something like that, I think I hate seeing those. I don't want to read them. I don't want to review them. That's a lot of pages and a lot of words. I like to really make them quite small. I think my longest shareholders agreement to date is about 11 pages. And that was because it had a lot to do with who was owing who money. And it was involving influencers in London as well, because it was a makeup brand. So there was a lot involved in there. Otherwise, I like to have it fair size. Right, I'm dyslexic, so I don't want to see little writing. So I like to have it fair size writing because I need to review these things 4 or 5 times, especially if I've written them. So I make the writing nice and big, spread it out, everyone can see it. So yeah, it's a common thing for all of my clients that say, I don't want to end up with a 30-page document. Nobody does, and nobody wants to see it on the other side either.
So my final question, and it's a really basic question, but I think it's really important. How important is it to read contracts, and is there anything that you can do to kind of look at them analytically to make sure that you're getting what you need from the contract and not signing anything that you really shouldn't?
Yeah, it's definitely very important to read them, and it's the cheapest but one of the best things that you can do. Read it yourself, because and then a lot of the time I will get specific clauses and say, can you actually just have a look? There's about 4 lines here, can you just have a look at this for me? That's all well and good. We're able to do that. It's really important to read them and put it into context of your business as well, and in that particular contract, what's that contract for? Put it into that context. And a lot of the time it's not even that I look at a contract, that contract is bad or that contract is good. It doesn't work like that, because what's good for one person might be bad for another, what's bad for another will be good for another. So we really need to take the context of where that business is and what this contract is for. What does the client want from it? And then I say, right, this clause says X. This is what will happen if this clause is triggered. Are you happy with that? Are you okay to still move forward with it? Yes or no, right? Move to the next clause. This is what this clause means. This is what happens when that clause is triggered. Are you happy with it? Unless we take it one at a time, it's really simple and easy, and they'll understand it a hell of a lot more. So really important to read them. And it's something I advise that somebody does before they get to me, because you might get the answer, but not only that, when I ask you questions, because you know how your clients work better than I do, you know your business better than I do, you know how you get paid and etc better than I do. So we need to have a meeting of minds. It's great if you've had a quick read of this, and you might even have a couple of questions that you can bounce off of me. You get some great feedback, and straight away we're already 10 steps ahead than you would have been if you just gave me a contract and said, tell me if this is all right.
Would you be able to tell everybody where they can find you on the internet, where they can access your services?
Yes, of course. So Soul Legal Services is the name of the company. So my website is www.soul-legal. Soul is spelled Sierra Oscar Lima Echo -legal.com. And I'm also on LinkedIn under my name and -Soul Legal. So I'm pretty much everywhere. But those are the two places that I can be found. And my email address is just my first name dot surname at soul-legal.com.
And we'll link all this below so that you can just click through and then you'll get straight through to Suraj and you can access his services. It's been an absolute pleasure having you on today. I think this sort of stuff is so important, and I think a lot of people will get a lot of informative information from this today.
It's been a pleasure. Thank you very much.